Good afternoon, everyone, and welcome to today's webinar on cancer-related employment discrimination presented by our friends at City Bar Justice Center. My name is Natalia Rodriguez, and I am the bilingual education specialist here with PSS Circle of Care. For those of you who might be new to us, just to give you a little bit of an overview of PSS, we are an innovative multi-service agency whose mission is to strengthen the capacity of older New Yorkers, their families, and communities to thrive. PSS Circle of Care provides free support services for those caring for someone who is frail, chronically ill, or is experiencing memory loss, and for families where a grandparent or a family member other than a parent is raising a grandchild. Some of the free services that we offer are consultations, support groups, education and trainings such as this one, wellness events, respite opportunities, supplemental services, information, and advocacy. For further information about PSS and the services we provide, please feel free to contact us via the email and the phone number that will be posted on the chat box shortly. Just as a reminder, this webinar is being recorded and will be posted on our resources page at pssusa.org/events and on our YouTube channel. As a reminder, should any questions come up during the presentation, please submit them on the Q&A section of your screen for an opportunity for our panelists to answer them during the Q&A portion of our event. So this afternoon, we are joined by Allison Greenberg of City Bar Justice Center. Allison, we're so delighted to have you. Welcome. And now I'll turn it over to you for the presentation.
Thank you, Natalia. And welcome, everyone. I can't see you, but I appreciate you being here, and I hope that what I have to share is helpful to you. Well, welcome everyone. And I just wanted to start off by telling you that I represent employees in the workplace. That's the focus of my law practice. I volunteer through the City Bar Cancer Advocacy Project. And I work with a lot of individuals who are confronting issues in the workplace, whether it's a violation of law, or perhaps someone doesn't know if their rights are being violated. Maybe they think they're being treated very unfairly. I do occasionally meet with, and when I say meet with, it could be virtual, it could be by phone, family members of people who have disabilities or other serious health issues. But just wanted to start off by saying that I give you so much credit for being here and taking time to find out about your rights, because you're doing so much to care for your loved one. And unfortunately, you need to juggle your workplace duties and rights along with caring for your loved one. So thank you for being here today. I'm going to start off by talking about some general anti-discrimination laws that tend to focus on the individual who has the disability, but that is important context to talk about your rights. So I'm going to talk about anti-discrimination laws. I will talk about paid leave. I will talk about unpaid leave and some other legal rights laws that may provide you with protection. And then at around 1:45 or so, maybe a bit earlier, depending on how much I've covered, I'll open it up to your questions. And so you can feel free to put them in the chat or the Q&A, but I probably won't answer them until that time. So some of the laws that I'll be covering include the Americans with Disabilities Act, or the ADA, the Family and Medical Leave Act, FMLA, state law, primarily I'm going to focus on the New York State human rights law and or other New York State laws focusing on employee and caregiver rights, the New York City human rights law, but some counties whether in New York State or elsewhere, have laws in addition to city, state, and federal laws. And I will also talk about ERISA, which is a federal statute that protects, it generally protects employee rights with respect to benefits such as pension plans, life insurance, health benefits, retiree plans, and sometimes the family members of people of the employee who was the insured, family members are the beneficiaries, and sometimes they come to me and go to other lawyers to seek information and protection about rights under ERISA. So categories of legal issues to be aware of: discrimination, the right to reasonable accommodation, which might generally not apply in your case, but I'm going to talk about it because you might assume it applies, but I will talk about when it might apply, even if you're a caregiver and not the person who is considered to be or is disabled. Unpaid leave, paid leave. You as a caretaker may have rights. It may be technically called associational. There's associational discrimination. We also now use language such as family provider, family caregiver rights, caregiver rights. The language is in flux. There are employee benefit protections that may govern. And on top of all of this, and as you've confronted with your loved ones and caring for them, we still have the challenge of COVID-19 and how that has impacted the rights of employees in the workplace, whether because of their health or the health of their loved ones. So the ADA, what is it? Many of you may, or most of you may know this, but I'm going to tell you anyway. It is a federal law. It applies to employers. And by the way, you'll have a copy of this, and later on, if there's some information that I don't cover, I will at that point mention that in case you want to write anything down. But you'll have a copy of this after the presentation of this PowerPoint. So ADA applies to employers with 15 or more employees, protects people with disabilities. I'll talk about how that's defined. The law protects people who are perceived as being disabled. And for your purposes, the ADA also provides protection to those associated with people who are disabled in the workplace. There were amendments in 2009 to the ADA, and basically, and this could be important, again, if you are considered to have an association with somebody who's disabled, but a person might have a disability. They might have a physical impairment or some other impairment. But if a person is hearing impaired and they use a hearing aid, they may no longer have the physical challenge of being hearing impaired. And this amendment in the law basically says, even if a person is disabled, but they might use a tool to help them with that disability, so it either removes or reduces the impairment, their person is still disabled within the meaning of the law. So if a person's leg was amputated and they use a prosthetic device for their leg, they're still considered disabled, even if this person can run a marathon. So that's something to keep in mind. And I have here at the bottom, must be ignored. In looking to determine if this person has a disability, these items, whether it's medication or a device that help this person with their disability, are to be ignored in determining if the person is disabled. It's as if the person didn't have this medication or device. That's when you look to determine, is this person impaired? And I'm going to try not to spend too much time on the person in the workplace who is disabled, but again, I want to provide you with context. So under the ADA, a person is protected under the law if they have a physical or mental impairment that substantially limits one or more major life activities, if they have a record of such an impairment, or if they're regarded as having such an impairment. Impairment is a harm or damage to a bodily system. Unfortunately, a common health issue is cancer. And to give an example of a record of impairment is if a person is diagnosed with stage 1 breast cancer, she goes through all of her treatment, her cancer is considered to be in remission, and she goes for her appointments and her checkups, her scans, her mammograms, and 10, 15 years later, she no longer, she's considered cancer-free. She still has a record of that impairment, and this person might still be, or likely would still be, considered having a disability for purposes of the ADA. Now, in terms of being a caregiver who is protected, it is unlawful under the ADA if for an employer to exclude or otherwise deny equal jobs or benefits to a qualified individual because of the known disability of an individual with whom the qualified individual is known to have a relationship or association. This is very wordy, and I've taken it from the federal statute. So what does this mean? Ultimately, if you, the employee, are working for an employer and you disclose that your husband has been diagnosed with a serious health condition and that he's going to be in some type of medical care for the indefinite future, and suddenly you're let go a week later, that may give rise to discriminatory behavior where you are denied the benefits of that job. If you're the only person who's let go a week later, I'm just giving a very skewed fact pattern, but you've made it known to your employer that you've otherwise been qualified for your job. There's never been an issue. You got positive performance reviews. You disclose that your husband or your wife, your spouse, your significant other suddenly has this serious health condition. You have this association or relationship with your significant other. This is known to the employer that your significant other has this serious health issue, which is deemed to be a disability. And then suddenly you're let go from employment a week later. It doesn't mean you have a viable claim of discrimination, but you're to be protected from that type of behavior. And that's just one extreme example of what an employer cannot do. An employer cannot make an adverse employment decision based on unfounded concerns about the known disability of a family member or anyone else with whom a job applicant or employee has a relationship or association. So in general, this means that you, the employee who has a familial relationship, or, you know, I'm not here today to talk about the nuances of, well, we're not legally married, but we've been living together for 15 years. But that's an association. You're living together as spouses, but just from a familial relationship, if you're married, or you've been living together as partners for years, your employer cannot make an adverse employment decision based on unfounded concerns about the known disability that your loved one has and how your behavior as an employee might suffer based on some assumptions that the employer has. This is discriminatory. So what does this mean? In general, what courts have done is they've come up with some of the categories of stereotypical thinking about people who have associational relationships. And in the New York area, the Second Circuit, that's the federal court that covers New York and Connecticut in particular. The court has looked to, well, if some, let's just say you brought a lawsuit and you allege that you were discriminated against due to associational discrimination, a court would look to see, were you discriminated against based on associational discrimination with your loved one because number one, expense, and that's often that has been in the past considered a typical assumed employer response. An employer finds out that your loved one has this serious health issue, you disclose it, and suddenly and I hate, I don't want to panic you. You've already been living with this and dealing with this, but worst case, somehow there's a change in your job, whether you're let go or you're demoted. And if it can be shown that the employer would have reason to think that their expenses might go up, if they're paying the premium, if they're covering your insurance, if they're self-insured, if there are other expenses that might go up, that's one, what can I say, like a tendency that courts look for when they're considering associational discrimination. Another is, is the employer making assumptions that you, the caregiver, might be distracted at your job because now you're confronting your loved one's serious health issues. And basically, the court is looking to see, is the employer, on the one hand, when it comes to expense, is there reason to believe that the expenses might go up? So that is actually something that might happen. But if an employer might assume that a person is distracted in the workplace, that's more of, in a sense, a discriminatory notion that a person cannot do their job focus, but also care for their loved one. So an employer, just to reiterate, cannot, based on unfounded concerns about a known disability of a family member or anyone else with whom a job applicant or employee has a relation or association. So if you're applying for a job or you're working somewhere for quite some time and you make it known to the employer that a close family member has a disability, that employer cannot refuse to hire you for that reason. They cannot terminate your employment for that reason. They cannot deny you health insurance coverage for that reason. They cannot deny you any other benefits or privileges of employment that are available to others. So you cannot be denied a bonus, so long as, depending on how the bonus is meted out and what is taken into account, you can't be treated worse than others because you happen to be married to someone or you have a child who has a serious health issue. Nor can you be subjected to harassment. An employer cannot harass you because of your association with someone who has a disability. Now, many of you may have heard of the term reasonable accommodation, and in general, under federal law, this is something that an employee who has the disability, where the employee makes a request, sometimes through a physician letter, sometimes the employee makes the request on their own, and they're asking the employer for some type of assistance to help them basically balance their disability with their job so that the person can fulfill their job functions, but with maybe permission to leave work early every 3 weeks because of chemo. Maybe this person needs to take some leave, unpaid leave, in addition to what might generally be offered. But this is because the person is going through some type of medical treatment. So when we think of someone who has a disability in the workplace, we often think of this person having the right of seeking a reasonable accommodation. I gave some examples. Others might be if a person needs to use a wheelchair, asking the employer to build a ramp so that the worker can get in and out of the office and around the office and do their job with this reasonable accommodation. And an employer might say yes. They might come back and say, well, here's a different reasonable accommodation that we're willing to provide. And under federal law, there's more of a focus on, for the employer, is it an undue burden? And that has its own analysis. So do you as a caregiver have a right to a reasonable accommodation? And generally the answer is no. So unfortunately, if you are needing to take time off from work, needing to leave early to drive your spouse to medical appointments, treatments, other types of things, you're generally not going to be entitled to the reasonable accommodation of those requests. However, if your employer is giving accommodations to people who who ask to leave early, who ask to maybe they're going to a baseball game, a little league game for their kid, and that is permitted, well, then you need to be granted the same type of accommodation. So if the employer is granting the benefits or privileges of employment to leave early, to come in late, to take a day off, then you as a caregiver have that right as well. From a practical standpoint, and I don't know any of you, I don't know how far along you are with your loved one's situations. Again, I don't know if this is something that you've already dealt with, but if you're new to this group, if you're new to this life of being a caregiver to someone who has a serious health issue, then there's a question of, should you tell your employer about your family member's disability or health issue, whether you're applying for a job or you're already employed? So it depends from a legal standpoint. The ADA does it provides protection against associational discrimination, but it's not as protective as this New York City human rights law and the New York State human rights law. So from a legal standpoint, it depends. And that's something where you should seek legal advice. And then it's also a matter of your personal comfort level and how much you really need to tell your employer. Do you need to tell your employer the details about your loved one's health condition because you think your employer might be more supportive of you? There might be compassion from people in the workplace. That's up to you. Many will say, don't share more than you have to from a protective standpoint. And that's only something that you can assess. If later on, let's say you're ultimately let go from work and you believe you were singled out because of your association or relationship with someone who had a disability. If you can't show that the employer was aware of your loved one's health situation, you're probably not going to be able to show that you were discriminated against. In order for an employer to be liable for discrimination, you need to show that the employer was aware, or, in the context of this type of discrimination, you need to be able to show that they were aware that your loved one had this health condition. And that you need to provide evidence that that was a reason or the reason why your employer let you go, not because the employer suddenly came up with some made up excuse about poor performance when there had never been a performance problem with respect to your work. So New York City and state law protections. I will tell you that when it comes to discrimination in general, the New York City human rights law is one of the most protective laws covering employee rights. The New York State human rights law used to be, I wouldn't say a mirror image, but very similar to and basically duplicated federal law. So in the context of disability discrimination, the New York State human rights law used to be very much in line with the ADA. And in recent years, there have been amendments so that even the state law is more protective of employee rights. I'm not going to go through the details about discrimination laws other than to tell you that, again, you're generally not going to have a right to a reasonable accommodation unless you can show that other people in the workplace are being granted certain privileges and benefits that you're being denied. And it's very fact sensitive. This is something where you really want to talk to a lawyer because you might think you're being singled out in some way that might not be material, but it might be. So you have, if you're working in New York City, if your employer's headquartered in New York City, you may have protections under the city human rights law as well as state law. Under federal, state, and city law, there's something called retaliation. We think of retaliation at times in a way that's broader than the law provides. Not everything that an employer does that is unpleasant or unfair or even demeaning is retaliation under the law. But if you've made it known to your employer in some way that your loved one has a disability, that you're the caregiver, which might just be obvious, that there are appointments, there's medication, there's stress, there are other things. But particularly, I think it comes up when there are appointments, if the person has a very serious health issue, if their condition is getting more grave, that may be where we start to see an employer, unfortunately, engaging in behavior that might be discriminatory. We hope that an employer will embrace you and be supportive. But if things are getting more grave, the employer might feel uncomfortable about it. The employer might worry, oh no, what if Jane's husband dies? What's going to happen in the workplace? How is she going to deal with customers? Don't assume the worst, but sometimes this does happen. So if you make it known to your employer that you do have this relationship, this association, and if you also object to behavior by your employer, if you say, I feel like I'm being singled out because I told you recently about my husband's health condition, and if you're terminated or if you're demoted, if your pay is reduced, there might be other factual things that show retaliation, but this could be retaliation under the law. So that's something to be aware of. Okay, sorry, I want to go back. New York City has protection that you may be aware of, which is for people who have caregiving responsibilities. And it's similar to what I've just discussed, but it's perhaps less formal, and it provides protection to people who are caregivers and protection against what might be false notions or stereotypes about people who are taking care of their caregivers. It provides protection to independent contractors. So if you're an independent contractor and you're working in New York City, you might have protection under this law. It provides protection even if a person is working without immigration authorization documents. And I'm now moving on because I'm looking at the clock and I see we don't have much time. I'm going to talk about the Family Medical Leave Act. So this is a law that provides up to 12 weeks of unpaid job protected leave per year. This requires your employer to maintain your group health benefits during this leave. And this is for you if you are taking care of a loved one. Again, sometimes the nuances of marriage, legal marriage, and thankfully, you know, things have changed and broadened in recent years. But whether it's this is if you have a family member, whether a spouse or a child, then you, the employee, will have this protection. This is not just for the individual who has the health issue. So your health rights, your health benefits will be maintained during this leave. And this generally will protect your job while you're out on unpaid leave for up to 12 weeks. And I emphasize unpaid. So your job is held, your insurance is protected, but you're not paid during that time. In order to have this protection, you must have worked for the company for at least 12 months and provided at least 1,250 hours over that past 12-month period. So unfortunately, if you're just starting a job, you haven't been there a full year, you're not entitled to this protection. Generally, it will only cover an employer that has 50 or more employees. If you're working for a company that is affiliated with other entities, and let's say there is a common HR or common manager, but they try to, maybe these different entities are held out as being separate, and the entity that you work for doesn't have 50 employees, there are ways to hold the employer liable by looking at the multiple entities to see if you add it up, do they have at least 50 employees? Again, that's something where you need a lawyer to analyze the situation and provide you with advice. And this leave is in order to be entitled to this leave, in addition to what else I mentioned, this is to care for an immediate family member, spouse, child, or parent with a serious health condition, or for you to take medical leave when the employee is unable to work because of a serious health condition. So I might have, unfortunately, I think what happened is I spliced a couple of slides. So I'm going to shift now and talk about New York State and New York City paid family leave. You have rights under local law to paid family leave, and that is paid leave to take care of a loved one. And if your employer terminates your employment, and it seems like that happened because you made that request, then there are forms you can fill out. You don't need an attorney necessarily. And I've provided the document number to find the form, but basically this is a form that you fill out, you file it with your employer, you send a copy to the state office that handles paid family leave denials, and also discrimination and retaliation based on paid family leave requests. You send that form in, and the employer has 30 days to respond. And after that, you have a right to seek a hearing from the New York State Workers' Comp Board. If you're successful, you might be entitled to reinstatement. You might be entitled to lost wages, attorney's fees, and up to $500 in penalties, which unfortunately is quite low, but at least you're entitled to this other relief if you're successful. And I'm sorry, I'm going back to FMLA. FMLA, you need to disclose what your how much time you need. You don't have to use all of your FMLA at once, so you may be aware of that. You can spread it out over time. And what is the protection? I mentioned that your job is protected, your insurance is protected. Does this mean that you're entitled to return to the same job? It depends. Generally, that is the intention. If the employer can show that there was somehow good reason to fill the position, but kept a position open for you, and if it's not a demotion, if it's not a reduction in pay, then you might not be able to show that there was a violation. But generally, the way the law has been interpreted is that you are expected to be returned to your position. You are protected from retaliation by your employer or interference with your right to FMLA. What does this mean? Interference is easier to show. Interference is you seek FMLA leave and then you're terminated and now you're denied the leave. That's interference. Retaliation could be similar, but retaliation you have to be able to show that there was an intention, that the employer is doing this, is taking some action against you, not reinstating you to your position, putting you in a lower position that pays less, or terminating your employment. There has to be more of a showing that it was done intentionally to retaliate against you because you took FMLA leave. Combining leave options. Many employers, more established corporations, bigger employers, provide for more options of combining FMLA, which is unpaid, with paid leave. They may have their own private paid leave policies on top of what is provided under law. But unfortunately, there are some limitations under the law. For example, you cannot take paid family leave if you're collecting short-term disability. And that's just one example. So what's most important is that you reach out to your human resources person, look at the website of your employer, get your employee handbook, get all of your benefits information so that you can assess what your options are, how to protect your job, how to pursue your benefits. And if that's something that's overwhelming, then find someone who you trust, who can assist you. It doesn't necessarily have to be an attorney, but it's somebody who's smart, who can understand this information and provide you with support as you evaluate what the options are for these benefits. New York State has paid sick leave law. New York City has Earned Sick and Safe Time Act, which provides for paid leave. This is, COVID has changed everything, and each time I do this presentation, things have changed a bit. Some of you may be confronting a situation where your spouse is, or your child is, immunocompromised, and perhaps the employer required everyone back to work. And that's a concern, and that's something we can talk about if people have questions about the overlay of COVID and working remotely on top of being a caregiver. ERISA is complex statute. It may not apply here, but it's important to know that if your loved one has benefits such as life insurance, a retirement plan, other benefits, you want to find out what rights your your spouse has. So it's about your rights as an employee, but also your spouse may have certain rights that you and your spouse should look into so that you understand what the rights are, what action needs to be taken to trigger those rights, what happens if your spouse's employment is terminated. If you're a beneficiary, where does that leave you? And ERISA provides very strict requirements for seeking information from the employer, whether in writing, who the letter goes to. So these are things to think about as well. In general, and this is easy to say, and it's hard to say though when I don't know the people I'm speaking to, but no matter what you're going through, no matter how difficult it is, you need to try to be stoic in the workplace. You have a lot of burdens on you, and it's important to try to find ways to cope with that. That's beyond me as an employment lawyer, but I always counsel people to find support and recognize that even if you're going through a really difficult time, your employer could still accuse you of insubordination, even if you have reason to get upset. Maybe you have reason to lash out. So you want to avoid, with all of the stress you're going through as a caregiver, engaging in behavior that can be used against you. And recognize that as much as you would hope that your employer would be supportive, an employer is going to worry about the bottom line, and whether they're a good person or bad person, whether it's a big company or a small company, that they want you to be a good employee. You don't necessarily want to be sharing too much information with your employer, and that you shouldn't necessarily be sharing information in the workplace to find compassion. You should find that support elsewhere, but you should not be afraid to pursue your rights. And it's a matter of how do you navigate that. So with that, I would like to open it up to questions. And there's some information at the back of the package as to resources to see, contact information, in particular for the City Bar Justice Center. I see one question. Oh, it's an email. does anyone have questions? Would you like to ask without putting it in the chat? I'm happy to do that as well. Natalia, do you have any questions that might be helpful to the group?
I think not a question, but more of a request. I think this was good information and definitely a lot of information. If we can just get, this to forward to our attendees, it'll be great, for them to have. And then someone just requested,
Contact
your
info.
contact info.
And what I'm also going to do is I'm going to add some more details about the paid leave laws, because I know that's very important, and I apologize for not including those details. I will add that in, and then if I don't get it back to you today, I'll get it back to you and Vivian this week, so that, Natalia, you can share it with the group, because I want to be giving them the information that they need.
Yes.
And Natalia, if you can just put this in the chat, I mean, just the intake number for Cancer Advocacy Project is the intake line where you would call and just leave a message about, with a brief statement on what your question is. Oh, it's on your last.
Is it here,
page.
Vivian?
Yeah,
At the last?
Yeah, it's at the bottom. If you
I'm
can
sorry.
see
Yes,
there.
this is.
Yeah, so you just call that number that Alison has on her thing, that last number, and leave a message there.
Wonderful. Yeah, just because as you were speaking, Allison, there are so many different situations with our caregivers, and so I think this was all wonderful for them to see it one more time and for them to be able to reach out. That would be great.
And I see there's a question here. We have a little bit of time. What if you replace the word cancer with anxiety? Does this hold some substance? That's an excellent question. Absolutely. So, but it also depends on. So here's the thing. If your loved one is suffering from anxiety disorder, that's considered a disability. If you yourself are suffering from anxiety because of what you're going through in being a caregiver and working and everything else in life, then in addition to having protections as a caregiver, you may also be deemed to have a disability. So you may have multiple protections in the workplace. So again, mental health diagnoses are often considered to be protected as disabilities. Cancer is a disability. And interesting, and also, and I didn't really touch on this, but because I was focusing on association with, so I was focusing on people being a caregiver, but the ADA and city and state laws that protect people who have disabilities, the laws also protect people who are perceived as having disabilities. So one can certainly imagine that if a person is a caregiver and they're under stress, that the employer might assume or perceive that this person has anxiety disorder or is depressed. And whether or not the person has a diagnosis, this person who is perceived as having this mental health condition might have protection in addition to associational discrimination protection. Does that make sense? And I just wanted to note that the Cancer Advocacy Project number is the number to contact if you need legal assistance. And Vivian Duncan, who is here, she runs the Cancer Advocacy Project. The number is 212-382-4785. And CAP can pair people up with the appropriate legal counsel, volunteer legal counsel.
Allison, I have a question for you as you started speaking. Let's say that someone is in the workplace and they've shown that they've had, for example, I think the word used was anxiety or depression, but felt unsupported by their employer and almost felt in so many ways like minor I know situations where they weren't be supportive and they've chosen to leave that position. Excuse me. Is there anything that that person can do? Should they desire to do something moving forward, or they've lost all sorts of whatever protections that might be?
No, and that's a great question. Well, it depends. So I use the word discrimination a lot today, and I was focusing on something that may be more clear cut, where a person's employment is terminated after they disclose information about their health, the health of their loved one. But an aspect of discrimination is also what's called a hostile work environment or harassment. And often we think of harassment as sexual harassment, and that's the only kind of harassment. Not all harassment rises to the level of harassment under the employment discrimination laws. But if a person might appear to or might actually suffer from anxiety disorder or depression or some other mental health condition, and if their employer, it's not that if the employer wasn't supportive, then there's a question of whether the employer should have offered a reasonable accommodation. It's very fact specific. But the New York City human rights law requires that if the individual makes it known, basically the employer might have the burden of entering into what's called a cooperative dialogue. If, on the other hand, a person either has a diagnosis or appears to have this diagnosis, and the supervisor in particular or other people are actively hostile to the person because of their mental health condition, and the person leaves, the employee might have greater rights. But if the employee voluntarily leaves, it might be difficult to show there's a claim, because typically you need to have this adverse employment action, which is termination of employment or demotion. And only if behavior is so objectively unreasonable that no reasonable person could handle being subjected to such behavior, can a person leave voluntarily and have protection. It's very hard to show what's called constructive discharge. But I'm a broken record, but it's also fact specific. So if people do have questions and concerns, they should certainly contact CAP and find the right attorney to ask questions and get some free, helpful legal advice. In the context of the Cancer Advocacy Project, and because we do focus on, and I'll leave it to Vivian. I don't know if this is something that would fall within CAP's.
You mean to what you've just been talking about today?
Yes.
Yeah, I mean, we would certainly try to ask one of our employment attorneys to talk that through with the person. Did I see another question come in as well, Natalia? Did another question?
I'm sorry?
Did I see another question come in?
Yes, another question that came up is says currently trying to remain as a remote worker based on anxiety, but it has to be proven and keep being redirected to reasonable accommodation to return or FLMA.
So then if you're being redirected, I would certainly follow those directions. And you probably, if you have anxiety, it's not that it has to be proven. You shouldn't have to prove it, but you probably do need to get a letter from a mental health provider, not disclosing your condition, but saying so-and-so's, and I'm not, I just want to be careful. I'm not giving legal advice, but in general, if something like this comes up, it makes sense to go to a healthcare provider who can provide a letter in confidence, provided confidentially to one person in HR. And then there may be forms you have to fill out, but you do need to follow those instructions.
Well, Allison, thank you so much again for your time. And also Vivian, Thank you, thank you, thank you. You know, this information has definitely been helpful and very eye-opening. And also to our caregivers, thank you so much for choosing to spend your afternoon with us. Please be on the lookout for a follow-up email, and don't forget to join us again in December 7th, for another webinar led by our friends at City Justice Bar Center. So yeah, thank you once again. You all have a great afternoon and a
Thank you.
wonderful rest of your week.
Thank
Bye.
you.